Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. My name is Riffat Hussain and I am your host this evening. As many of our viewers will be aware, the free legal advice show allows our viewers to call with their legal questions and receive an answer. You can call by ringing the telephone number on the bottom of the screen, or if you prefer not to come through live, then you may wish to send a message through WhatsApp. Again, the number is at the bottom of the screen. The show allows you to ask a variety of questions in relation to English law. You may wish to ask in relation to an immigration matter, an employment law matter, a criminal matter, or any other legal issues that may arise. It may be necessary for me to take some further details before I am able to give you an answer to your question, in which case I may do so live if you are calling in, or I may ask our control room to take your details so that I can speak to you later on. As the name suggests, this is a free legal advice clinic, and whether your question is received during the show or after the show, if I need to take some further details, then that free legal advice will be delivered. In terms of this evening, we have already received a number of questions that I will begin to address for you. The first question I have received is from a sister, Sarah. Sarah has asked in relation to an immigration issue. Her question specifically relates to the financial requirements for a spouse visa. Sister Sarah asks that she no longer meets the financial requirements for the spouse visa. Is there another way that she can invite her husband to the United Kingdom? The question raises a number of issues. This would be an entry clearance application, so I assume that Sister Sarah's husband is not currently in the United Kingdom and she is seeking to invite him to join her here. The issue for her, however, is that one of the requirements of the immigration rules is that she must satisfy that the financial circumstances meet the Home Office criteria, namely that there is a combined income for her and her husband of £18,600 gross per annum. Now, unfortunately, because this is a question that has come through on WhatsApp, I have little further details. However, Sister Sarah's circumstances could fall into a number of categories. It may be that Sister Sarah does not meet the financial requirements because she is unable to work through either disability or through somebody else's disability, which has resulted in her being a carer for that person. If that's the situation and Sister Sarah is in receipt of either disability living allowance or personal independence payment, as it is more commonly known now, alternatively, if she is in receipt of carer's allowance, then she would be exempt from the financial requirement under the immigration rules. It may alternatively be the case that Sister Sarah is unable to meet the financial requirements through loss of employment or income because of the COVID-19 pandemic. There are exceptions and concessions in place at the moment from the Home Office with regard to this. If the income has been lost due to the COVID-19 pandemic entirely, and this was between March 2020 and the 31st of October 2021, then the Home Office will look at income immediately before the loss of income period. So if Sister Sarah is able to meet 6 months, if Sister Sarah is able to demonstrate that she met the requirements for 6 months prior to the income loss, then the Home Office will take that into consideration also. My understanding is that we currently have a caller on the line, so we will go directly to our caller. Assalamu alaikum.
Wa alaikum assalam, sister.
Walaikum assalam, brother.
Yeah, sister. I got a question. Actually, I got a hearing on 26th of August last month,
Yes.
and that was cancelled because the Home Office said that we are launching some new policy within 6 weeks for people who are from Afghanistan. So my question is, just after that 6 weeks, they're going to give me straight away the hearing, or is going to be like I have to wait until they publish the new policy, please?
So thank you so much, brother, for your question. And if you continue to watch, I will give you the answer to your question. The Home Office has not yet introduced any policies, unfortunately, in relation to Afghanistan. It had earlier announced that there would be a resettlement program, but the details of this have yet to be announced. I understand that the resettlement is in relation to individuals who worked with the Allied forces, and particularly with British forces in Afghanistan, and their family members. If your case has already been refused by the Home Office, then it is likely that the Home Office do not accept that you were either a worker of a company or a direct worker with the armed forces. I don't believe that there is yet a policy, and I'm not aware of a 6-week time frame in which the Home Office is seeking to make such policies available. I would think that the Home Office will reconsider your case, and unless they feel that they are able to grant you some form of leave, then you will probably have another hearing listed for the matter to be determined by an immigration judge. I hope that answers brother's question in relation to his immigration matter. I do have another question on WhatsApp, which I will again proceed to read out. This question is in relation to a family law matter. The person who has left the message, unfortunately, hasn't left a name. So I don't know if it's a brother or sister, but I will read their question. If I get a divorce under Islamic law, do I also need to get a divorce under English law? The brief answer to your question is yes. Islamic law is not the law in England and Wales, which is the applicable law in this country. And therefore you would require a valid divorce under English law in order to remarry and to be considered properly divorced. So you can, the answer, as I say, is yes, and you can contact your local county court for further details on how to petition for divorce, or you can go online and find further details. If you feel that you require some further legal assistance in relation to this, then you may want to look up a family law practitioner on the Law Society Find a Lawyer page. Moving on to another question, again by WhatsApp, and thank you so much for sending this through to us. This question is in relation to a sister who seeks to invite her mother to the United Kingdom. The sister says, my mother has health issues and is alone in Bangladesh. Is there any way I can apply for her to come to the UK so I can take care of her? Now, this is a rather complex part of the immigration rule system. There are provisions which do allow individuals to invite their parents, grandparents, or siblings, or even adult children, so children over the age of 18, to come to the UK. But there are some strict criteria in place for this. And unfortunately, over the years, that criteria has got even stricter. The requirement essentially would be that you must demonstrate that you are unable to provide the practical and financial support and care required for your relative or for your mother in this case, whilst she remains in Bangladesh. And you would need a lot of persuasive and strong independent evidence to explain why that support cannot be provided in Bangladesh before your mother would be permitted to come to the United Kingdom. Whether or not your mother is permitted and what leave is granted to her will depend very much on your status as well. If you are a British citizen or a person settled in the United Kingdom, then your mother would be granted indefinite leave to remain, so also settled status if her application is successful. If you have limited leave to remain, then your mother would also be granted limited leave to remain in the United Kingdom. But as I say, the evidential criteria is a very strict one, and therefore I would advise that you seek legal assistance and guidance in the evidence that you submit to the Home Office as part of this application. My understanding is that a very high percentage of these applications are refused for the lack of evidence demonstrating that the practical and financial support required cannot be obtained within the country of residence. And I hope, Sister, that answers your question. I do have another question again by WhatsApp, so thank you very much for sending this one through. The question is, my son has been in Pakistan due to COVID and personal reasons since March 2020. He has indefinite leave to remain for the UK. Do you know how long he is able to stay there where it will not affect his visa? So in terms of indefinite leave to remain, an individual is permitted to stay outside of the UK for a period of 2 years. If your son is unable to return, therefore, by March 2022, he will need to apply for a returning residence visa, which he can do so on the Home Office website. But at the moment, he has plenty of time to get back to the United Kingdom within the permitted time. We are taking a short break, and I will see you on the other side of that break. Thank you. Assalamu alaikum and welcome back. I'm your host Riffat Hussain, and we are now in the second segment of the free legal advice show for this evening. As viewers are aware, this is an opportunity for our callers to put their legal questions to me and receive an answer to any queries that they may have. I deal with all aspects of English law. And so please do feel free to contact me this evening, either by calling the telephone number or by sending a WhatsApp message. Both numbers you will find at the bottom of your screen. Before the break, we were dealing with a number of questions that I had received through WhatsApp, and I will continue to do so. Please do send any questions you have through to us so that I may be able to help you this evening as well. I have another question here, and I will just read through this. So the questioner asks, my question is, how can a child apply for their mother to come to the United Kingdom because the mother has been divorced in Pakistan and the child has a British passport, but needs the mother to look after her and needs the mother to be with her in the United Kingdom? The question is quite vague and doesn't provide a great amount of detail which would allow me to give you a reflective answer of the severity of this issue. So it's unclear, unfortunately, how old the child is and whether or not the mother has previously been in the United Kingdom and the circumstances around that. What I would therefore request is if either the caller is able to contact us by telephone, or if they are able to provide some further details to our control room, then I will be able to address that question for you. So thank you. I have another question here. This is quite a lengthy question, so I will try and summarise as much as I am able to do so. a similar question to the last one that we had. So my wife's cousin, who was taken to Pakistan and dumped there with her 6-month-old baby girl. Her 2-year-old son was taken away from her by her husband. He took her passport and all her documents with him to the UK. She could not travel to the UK because of a lack of documents. Is it possible for her to come to the UK? Her baby girl is now 18 years old and has got her British passport. She can come at any time to the UK, but her mum has no passport or any documents. She was in the UK for 2.5 years, had 2 children in a location which I won't mention, but she was tricked and taken back to Pakistan and dumped there. So the questioner does answer most of their question in respect of the daughter that was left in Pakistan. A British citizen with a British passport is free to travel to the United Kingdom as and when she wishes, without any restriction as a British citizen. The question specifically is in relation to the mother of this child, who appears to have been in Pakistan for at least 17.5 years, and now wishes to return with her daughter. It's unclear whether the son who was taken away from the mother is still in the United Kingdom, and whether or not he has any contact with his mother. Again, the questioner is providing not sufficient information, unfortunately, for me to give a real answer. There could be a number of avenues open to this lady to apply to come to the United Kingdom. One would assume that the question is whether or not she can come and settle in the United Kingdom. And again, that's not clear. That there would be limited routes to settlement for this lady at the moment. But again, each case would depend on its very particular circumstances, and those are not apparent within the limited information within this question. There certainly may be provision for this lady to come to the United Kingdom on a temporary basis, for instance, a visa. But again, more comprehensive legal advice based on more information around your circumstances would be advisable to have a clear picture of this lady's options and whether or not she can return to the United Kingdom. I have another question, and this time, Assalamu alaikum wa alaikum assalam. The marriage took place and was registered in Pakistan. Wife is a national of Pakistan and I am British. Marriage is not registered here in the United Kingdom. I want to divorce her since she doesn't live with me and it's clear that I was made a fool of and used. Now, again, the questioner doesn't make this clear, but it would seem to me that the wife is already present in the United Kingdom, and the person asking the question is wanting to know whether they can divorce, and what their position would be. It would depend on the location of the individual as to where the divorce is registered. If it's a marriage that's broken down and the individual are not living together and have no intentions to live together, then each party has a right to annul that marriage. Whether that marriage is annulled in the United Kingdom or in Pakistan will depend on where these parties are. If one is to assume that both parties are in the United Kingdom, then the divorce will need to be petitioned for in the United Kingdom, even though the registration has not taken place in the United Kingdom. I hope that answers your question. moving on to some other questions, and thank you very much because they are coming through thick and fast this evening, and hopefully I'll be able to get through them for you. So a questioner asks, I would like to invite my mother-in-law to the UK on a visit visa. Do I need to prove that I can financially support her? Or if so, sorry, forgive me. Do I need to prove that I can financially support her? And if so, is there a minimum salary requirement? There is no minimum salary requirement. You are required to show that you have adequate funds to support the visit. You may wish to sponsor the visit, or your mother-in-law may wish to sponsor her own visit if she has sufficient funds to do so. So the onus is not purely on the person in the United Kingdom. What is adequate funds will depend on the particular circumstances of what this individual is wanting to do in the United Kingdom and how that will be funded. So the requirement is not a fixed one. I have a particularly lengthy question which I received during our break, and I will aim to do justice to this question and provide an answer also. This is a sister who asks, I have lived in the United Kingdom since 2008. We entered the UK in December 2008. This sister came to the United Kingdom as a sponsored student on a PhD course from her native Libya, forgive me. The sister then suspended her studies some years later and returned to her country for some field work, where she remained in for around 10 months. There's quite a lot of detail, sister, which I will omit so that I can get to your answer. So stayed in Libya for 10 months, although the plan originally had been to stay there for 5 months or 4 months. But the sister was pregnant at the time and remained for a longer period in order to deliver her child there. There's also conflict in Libya, which prevented the sister from coming back as planned. Upon returning to the United Kingdom, the sister then reapplied for further studies. The sister's question is, in summary, that she has been in the United Kingdom for, or will have been in the United Kingdom for a period of 10 years in 2023. And she's wanting to know whether she can apply for indefinite leave to remain under the 10-year lawful residence rule. Yes, there are more details within this question, sister, unfortunately, which would reflect the answer that I provide to you. So I would ask that you do call back and leave your details with our control room so that I can take those details before I give an answer. With regards to the long residence rule, however, in general, the requirement is that there is unbroken residence for a continuous period of 10 years, although there are some exceptions to this. We are coming towards the end of the programme today, and I thank you for joining me. I will be back next week on Monday at 7 p.m. Assalamu alaikum wa rahmatullahi wa barakatuh.